Be ready. 5 seconds. I have heard learned counsels for the appellants as well as learned SPP for CBI. Stop para. In the trial, the complainant was examined as PW1 and his deposition was recorded on multiple dates. Stop. His examination in chief firstly took place on 3/6/1997. Stop. On that day, he deposed that he was looking after the work of taxi service on behalf of his brother, who was the proprietor of Sharma Taxi Service. Stop. He deposed that on the intervening night, their driver was apprehended by the police officials. Stop. The examination was deferred at the request of prosecutor. Stop. In his further examination in chief that took place, the complainant stated altogether new facts, which were neither stated in his complaint nor in his statement recorded under section 161 CRPC. Stop para. Notably, on this day of recording of deposition of the complainant, the trial court noted in its proceedings that the complainant had complained of having been threatened by Ram Dutt, who had allegedly visited his taxi stand a day prior. Stop. In fact, the trial court proceeded to cancel the bail and sent him to judicial custody. Stop. The complainant's further examination was deferred for the next day. Stop para. In the considered opinion of this court, the above circumstances cast a reasonable doubt on the prosecution case as well as the aspect of demand. Stop. While learned counsels for the appellants as well as learned SPP have referred to several decisions on the aspect of proof of demand and acceptance of illegal gratification, however, recently the said aspects have been authoritatively determined by a constitution bench of the Supreme Court in Neeraj Datta v. State Government of NCT of Delhi Stop. It has been held that the initial burden is on the prosecution to prove that there is a demand of illegal gratification and subsequent acceptance as a matter of fact. Stop. After evaluating the entire case law on the aspect of proof of demand and acceptance of illegal gratification, the Supreme Court summarized the legal position as under: para. The presumption of fact with regard to the demand and acceptance or obtainment of an illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof. Stop. Of course, a presumption of fact is subject to rebuttal by the accused, and in the absence of rebuttal, presumption stands. Stop para. In the event the complainant turns hostile, or has died or is unavailable to let in his evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witness who can again let in evidence, either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. Stop. The trial does not abate nor does it result in an order of acquittal of the accused public servant. Stop para. The facts of the case, when examined in the light of the aforesaid decision, allows this court to reach the inevitable conclusion that the prosecution has failed to prove beyond reasonable doubt, the demand of bribe as the same is a fact of issue. Stop. It is trite that presumption under section 20 of PC Act is subject to rebuttal by the accused, and further, the same does not apply to Section 13(1)(d) of the PC Act. Stop. Consequently, the appeals succeed and the conviction is set aside. Stop.